Santillana versus 18th Judicial Circuit.
Good morning, Your Honor. My name is Mike Jones here on behalf of the appellate. We have before us not an issue of facts, but an issue of interpretation of the statute known as the Whistleblower Act. The appellant filed a claim with the commission. The commission denied the jurisdiction, saying that it could not investigate the claim because the state court system was not a party, not a part of, or not covered under the Whistleblowers Act. When you look at the Whistleblower Act itself, the intent is set forth at 112-3187, Premp 2. Very clear, and this court had before it.
Well, but the issue here isn't whether the Whistleblower Act applies to the court system. I don't think that there's any dispute that it applies to the court system. The issue here is whether the Florida Commission on Human Relations, whether they have the authority to investigate that. If there's a violation of the Whistleblower Act by an employee within the judicial system and there's an adverse employment consequence as a result of the actions by the employee, then there's a remedy under the Whistleblower Act. You can file a lawsuit.
Well, then what's the intent? What's the purpose of the Whistleblower Act? And you can file a lawsuit anyway.
It gives the employee a remedy.
Well, you have to look at the thing in its totality, the statute itself and the intent. And I noticed the 4th DCA in their recent case in 2003, they did the same thing that the commission is trying to have you do today, and that's to focus upon the legislative act being a state agency, so forth. What they have made to me is a circular argument. They're saying, well, we have jurisdiction, but we don't have to investigate it under that 3195.
Well, how about separation of powers?
Well, that's covered in that. I think that's why they made reference in 216 to that one line there. That was part of that definition 216, but I don't think it had anything to do with the investigations. There's nothing. In fact, the Inspector General has the authority, as does the commission, to investigate claims under the court system. What the argument I got from the state was, we have my clock didn't start.
Oh, I'm sorry.
That's all right. I get all that free time. What I understood them to say was, we don't have to investigate this because it's covered under 95. Well, 95 covers a lot of things. And if you, that's, 31, 90, 87, 95, whatever it was. And it says in there that different types of investigations. And if you have a public employee that works for a city or a county or something, and they have their own investigative remedies inside, then that's what you got to follow before you go to the commission. I assumed when I first got this that they were looking for some kind of investigative procedure in the court system, but there is none. There's no procedure that you have to go through. So the only one you're going to go to is to the commission itself. And when you get to the commission, then what they want to say is, well, it's an agency thing. And they hung their hat on the agency. I didn't see that because clearly in 216 it says state agency and agency. They're both the same under the definition. But I think that the commission then argued, well, that's more specific than the definition under the Whistleblower Act, because that definition covers everything, pretty much everything. But 216 is specific in that it tries to exclude the judiciary. And that may have been the case back in 2000, but certainly when the legislature inserted but not limited to, that's a heck of a lot broader than what's found in 212. So you can't say that the 112, you can't say that the definition in 216 is more narrow than the one in 112 when it contains the language, but not limited to. And they put that in there for a reason.
But what is the language at the language at the end of 216 says, solely for the purpose of implementing Article 3 of the state constitution, the term state agency or agency includes the judicial branch.
Well, if you have to look again at the whole statute, and 216 is a budgetary planning statute. Totally, I don't know how you can equate a budgetary statute with an employee relations statute, as the Whistleblower Act is. But they picked this out of nowhere.
Well, let me ask this. Do you agree that the Human Relations Commission has the authority to investigate those bodies set forth in 216.011? I mean, are we okay on that? That under the if you file a whistleblower complaint with the Human Relations Commission, they're empowered to investigate those bodies.
I would agree with that.
Okay, so when we look at 216.011 and we see, what bodies they're entitled to investigate, it means any state agency or agency means any official, officer, commission, board, authority, council, committee, or department of the executive branch of government. All right, let me just stop there for a minute. Can we agree that the judiciary is not any of those things because it's not a part of the executive branch of government?
I think so.
All right, so then we go on to the next sentence. For purposes of this chapter and chapter 215, state agency or agency includes but is not limited to state attorneys, public defenders, criminal conflict, civil regional council, capital council, justice administration, public service commission, and finance corporation. All right. Do you think that the judicial branch falls under the umbrella of any of those entities?
I do.
And which one would that be?
I think it would fall in anyway under the what they stuck in there in 2000, but not limited to.
So,
I mean,
so you all right. So your view would be that the term state agency or agency includes, but is not limited to. So you think that the not limited to language essentially is then broad enough to sort of capture in the net virtually any part of state government, including the judicial branch.
Your Honor, if you look at the purpose of the Whistleblower Act, stated in the intent of the Act, it's got to be. Otherwise, you're going to take, like the fourth did, and say, well, it only applies to these specific people, the state attorneys, public defenders, and executive branch.
Well, I think that the difference that we might have on that point is not that the Whistleblower Act doesn't cover the judicial branch, but the question of if there's an alleged violation, who has the authority to investigate it? And really what it comes down to, I think, as Judge Cohen mentioned earlier, is it seems to me that this statute was drafted as a separation of powers concern, that they didn't think that an administrative agency of the state, and I assume that the Human Relations Commission, I guess, is probably part of the executive branch of government, that the executive branch of government could constitutionally investigate the judicial branch. And that doesn't mean that judicial branch has the authority to punish whistleblowers. I think what it means is if you think that there's a whistleblower violation within the judicial branch, you have to bring it to the attention of the judicial branch, and they have an inspector general, and that they can look at it, and if they tell you that we don't see a violation as occurred here, you then have a right to file a lawsuit in the same manner as you would if the Human Relations Commission said we don't see a violation. I don't see that this changes the remedy at all. It merely directs you to whom you are intended to
the purpose of the statute,
assert your complaint.
I thought the purpose of the statute was to protect public employees and the people from getting ripped off. That's what I thought. So if you're going to have an investigative arm, why isn't that applicable to all the branches of government. You're talking specifically about the judiciary, but what about the legislative branch too? I mean, and if you look at some of the things that you get out of the Whistleblower Act that you can't get out of a lawsuit, you know, the first thing, if I file a lawsuit tomorrow, the first thing you're going to hit me with, failure to exhaust administrative remedies, be the first thing they raise. And then we go through the same argument again.
Well, but if you get your letter from the Inspector General of the Supreme Court, as you did in this case, that says we don't think that you have a valid complaint or we don't have evidence of it, you know, the basically forget it letter that you might get from the Human Relations Commission or you might get from the Inspector General, the ability to file a lawsuit and the remedies that lawsuit would result in are identical. I don't see where there's any difference at all.
Well, there is if you file the lawsuit, and under that 31895, the commission can expedite orders. They can put you back to work. You know how long it'll take it to go through the system if you file a lawsuit? I mean, you can't equate what the commission was intended for. I don't care what branch of government, with a lawsuit. And you know what that is. We're talking 6 weeks or 8 weeks or a year before you get into the discovery process, even determine if you have the evidence that you need. I mean, you know that you just can't just walk in there and get it from the court system. So I don't think you put the people in the legislative and in the judiciary branch on the equal footing that you do with the executive, and I don't think that's what the legislature intended. I think they intended for it to be.
If we assume that the language, but is not limited to, is somehow broad enough to include the judicial branch, which is your argument, then doesn't that argument render meaningless the last paragraph or the last sentence, which says solely for the purpose essentially of budget planning, state agency includes the judiciary?
No, because then you got to go look at what that statute's for, what that section is for, and that section's budgetary and planning. That would be your separation of powers argument, and I think that's cited with in one of the cases that I'd mentioned.
But let me shift gears on you for just a moment, and admittedly, I'm going to ask you a question that you may not be prepared to address, and it's a jurisdictional question that's been bothering me about this case. If I understand it from the record that was filed with us, the Human Relations Commission writes a letter to your client on February the 26th and says, we don't have the authority to do this, essentially, and if you think we're wrong, notify us within 10 days. Now, in fairness, for completeness, they go on to say you've got a second inquiry which alleges employment discrimination separate and apart from your whistleblower complaint, and we need more info on that. So part one, whistleblower, they say, not within our jurisdiction, but if you think you're wrong, let us know in 10 days. That's February the 26th. At the end of March, there's a letter that's from you dated the 28th of March and received by the agency April the 1st, a couple of days later, that asserts why you think they were incorrect. And then they write you back a couple of days later, the 4th, and they say, no, we got your letter, we still think we're right, here's why, and if you want to appeal, you've got 30 days. I guess my question is, since the normal rule would be that from final agency action, you've got 30 days to appeal, why wasn't the February 26th letter that says, we don't have the authority to investigate this, and if you think we're wrong, let us know in 10 days, essentially request a rehearing, why wasn't that the final agency action?
Well, I didn't consider it final agency action, and you have to have something. It's been my experience, and I've been against many government agencies, it's been my experience that you've got to have something in writing. This is final agency action. You can't just assume it, like a zoning board or anything else. You can't just assume because somebody says, I'm not going to do it, that it's a final agency action. That's why the letter was a ticket. But now, there's two parts of this thing, you're right. And the second part, they didn't file their paperwork up there correctly at the same time. They filed the whistleblower complaint, and 180 days started to run on that. They didn't file the Discriminatory Act until after we filed this appeal, or in the process, and they realized they hadn't. So that was filed later, and that 180 days started to run on a separate investigation. So procedurally, I don't know from the commission itself if they send out this type letter to everybody, but certainly you need something that indicates a final agency.
So your view is that somehow this has to say this is final agency action, and you've got 30 days to appeal, which they clearly said in the second letter. So absent that, even if the second letter essentially said nothing more than, hey, we said it the first time in our first letter, your view is unless they essentially advise you that this is final and you need to exercise your appellate rights, that it isn't final until then.
Well, that's the second thing that they hit me with. Failure to exhaust administrative remedies, and so, not final agency action. So, yes, from my experience. But there's a couple of things that are troubling. What do we do now if this court deems that we're incorrect and the commission is correct and it's limited only in this situation? Has my time been told to bring that action, a civil action, because of the pending appeal? And I can't find that. It's not addressed in the case law. So, what for the person who, and I pointed out here, most people who come with a Whistleblower Act are under the thumb anyway. They've either lost their job, as the statute continually says, they're unemployed or previously employed, or an applicant. They don't have the wherewithal to go out and do all this stuff. I mean, that's what the legislature, I believe, had in mind, was to help the employee, not to take the balance away from it. And for this to be twisted around by a budgetary planning statute and definition is beyond me. I mean, I follow it. I mean, I see the argument. It's the circular argument. It comes back to you lose anyway. Thank you.
May it please the Court, Renee Gordon with the Office of the Attorney General on behalf of the 18th Judicial Circuit, the appellee in this case. Your Honors, what the appellant is looking for is a legislative remedy, not a judicial remedy. I submit to you that the FCHR did not err in refusing to accept jurisdiction over appellant's whistleblower complaint, and it did not err in its interpretation of Section 216.011 as circumscribing its jurisdiction over that complaint. I've reached that conclusion by considering the plain language of the statutes, the remedies contained in the statutes, and the deference that we should give a state agency charged with having to enforce the particular statute. In presenting her argument, plaintiff urges the court to perform a statutory construction analysis that requires an exploration of legislative history. Well, this approach is wholly unnecessary. The plain language of the statutes is unambiguous. Therefore, there is no statutory construction needed. All we need to do is look at the plain letter of the law. If you look at Section 112.31873, that part of the statute simply tells you which entities are covered under the Whistleblower Act. Section 112.31878 outlines what the remedies are. And it is in that statute that we're referred to Section 216.011. There, the legislature chose to define state agency in the first line of that section as any official, officer, commission, board, authority, council or committee, or department of the executive branch of government. It is clear there that the legislature specifically was concerned with the executive branch. Now appellant would have us to believe that allowing the FCHR to only investigate complaints from executive branch employees somehow discriminates against judicial and legislative branch employees. But it does not. The Whistleblower Act itself has a remedy for all public employees. If you are not able to file a complaint with the FCHR under 112.31878A, then you can go and file a civil action. If you're a local government employee, then you can file with the proper local government employee authority. Therefore, employees, all employees, are covered under the Act, and none are discriminated against. Appellant makes much of the FCHR's reference to 216 because it's in a chapter that deals with fiscal affairs. It's not unlike the legislature to look elsewhere for definitions that limit the scope that it wants a law to apply to. For instance, the legislature recently passed the Domestic Violence Leave Act. I believe it's Chapter 498 of the statutes. And they drew on a definition of employer in the workers' compensation statutes. That statute has nothing to do with leave or domestic violence. But the legislature wanted to limit the type of employers to which the Domestic Violence Leave Act would apply. And so it chose to use that definition. That is not an uncommon practice in the legislature. Finally, I'd like to call your attention to a 1985 case, the Public Employees Relation Commission versus Dade County Police Benevolent Association. In that case, the Florida Supreme Court considered whether a lower court's overturning a PERC decision, which itself overruled a hearing officer's decision, was proper. The Supreme Court upheld the PERC decision and stated, a reviewing court must defer to an agency's interpretation of an operable statute, as long as that interpretation is consistent with legislative intent and is supported by substantial competent evidence. The legislative intent of the Whistleblower Act is to protect public employees, and that's what it does. There's no ambiguity in the statute, and I encourage you to look at the plain language. Thank you.
Thank you, Counsel. You got anything further?
Well, when the judge doesn't ask any questions, it makes me nervous. In response to her argument, the agency should not be given the last decision on the interpretation of the statute. This court has overturned many statutes. I recall the last one I was here on, Judge Sharp asked me, what do you want us to do? Do you want us to tell the legislature they're wrong? And my response was, yeah, that's your job. You're the only one that can do that. You know, we can't do that. And you know, I mean, the language there clearly causes concern and problem. It supports their side. It's the 4th DCA found that. But you know that's not right. That's not right. It's just, that's not what the legislature meant. The legislature meant for everybody to be protected equally and not hiding behind some budgetary definition. Thank you.
Thank you, Counsel.